This is a story that's been told many times before. A person or a company invents a new technology or creates an original work of art. They spend years developing it, investing time and money to make it a reality. And just as they're about to reap the rewards of their hard work, someone else copies their invention or work and brings it to market. The result? The innovator is left with nothing, and the copycat thrives on their stolen ideas. It's a frustrating situation, but one that's becoming increasingly common in today's globalized and digitized world. In 2019 alone, U.S. companies lost billions of dollars to intellectual property theft. In China, nearly 73% of executives surveyed said that IP theft had affected their company, and those losses were estimated at over 1.6 trillion yuan, or roughly $240 billion US. And it's not just big businesses that are affected. Small and medium-sized enterprises also suffer greatly from IP infringement, with losses estimated at $280 billion US annually. So how do we combat this growing problem? How can we stop the copycats and protect the innovators? To answer these questions, we need to understand the science behind protecting intellectual property in our increasingly copycat world. Today, we'll talk about the legal ways your ideas are protected. We'll look at the latest scientific developments being used in the fight against IP theft. We'll explore some of the challenges and opportunities in this exciting field. Welcome to the channel, The Know, one place for professionals to learn about the latest in engineering, science, and technology. Here we would like to thank all of our patrons for supporting us. If you would like to support us, go ahead and check out our Patreon page. Several legal instruments protect intellectual property. Let's first discuss patents, which protect inventions. Patents grant inventors exclusive rights to their inventions for a limited period. In the United States, the patent term is typically 20 years from the date of filing. During this period, the patent holder has the right to exclude others from making, using, or selling the invention without permission. Patents are territorial. This means that a patent granted in one country does not provide protection in another country. Therefore, it is common for companies to file patent applications in multiple countries to ensure comprehensive protection. The three types of patents are utility patents, which protect new and useful processes, machines, manufactures, compositions of matter, or improvements thereof. Design patents, which protect new, original, and ornamental designs for articles of manufacture. And plant patents, which protect new varieties of plants that are produced by asexual reproduction. Utility patents are the most common type of patent and require that the invention be novel, non-obvious, and useful. To obtain a utility patent, an inventor must file a patent application with the United States Patent and Trademark Office. The application must include a detailed description of the invention, including how it works, as well as one or more claims that define the scope of the invention. Once the USPTO determines that the patent application meets all of the requirements for patentability, a patent is issued to the inventor. Patent infringement occurs when someone makes, uses, or sells a patented invention without the patent holder's authorization. To establish infringement, it must be shown that the allegedly infringing product or process falls within the scope of the patent claims. Copyrights protect original works of authorship, including literary, dramatic, musical, and certain other intellectual works. Unlike patents, copyright protection arises automatically upon creation of the work. However, registering a copyright with the U.S. Copyright Office can provide additional benefits, including the ability to collect statutory damages and obtain an injunction. In the United States, the duration of copyright protection varies depending on the type of work and when it was created. It's generally works published before 1978 have a duration that is either 28 years from first publication or 47 years from first publication if the work is still in print, whichever is shorter. Works published in or after 1978 are protected for the life of the author plus 70 years. Copyright infringement occurs when someone reproduces, distributes, displays, or performs a copyrighted work without the copyright holder's authorization. To determine whether infringement has occurred, courts generally use a two-step approach. First, the court will determine whether the allegedly infringing work is substantially similar to the copyrighted work. Second, if there is substantial similarity, the court will determine whether the allegedly infringing work is a copy of the copyrighted work. Trademarks are symbols, designs, or words that identify and distinguish goods or services of one party from those of others. Trademarks can consist of words, logos, symbols, sounds, or even colors. In the United States, trademarks are protected under the Lanham Act. To be protectable, a trademark must be distinctive and non-functional. This means that the mark cannot be merely descriptive of the goods or services and must be capable of identifying and distinguishing the source of the goods or services. Trademark infringement occurs when someone uses a mark that is likely to cause confusion with a registered trademark. The likelihood of confusion is assessed based on several factors, including the similarity of the marks, the similarity of the goods or services, the strength of the senior party's mark, the evidence of actual confusion, and the intent of the junior party. And lastly, we have trade secrets. A trade secret is any confidential information that provides a business with a competitive edge. Trade secrets are protected under both state and federal law. Unlike patents and copyrights, trade secrets are not registered. Instead, protection relies on maintaining the secrecy of the information and taking reasonable measures to prevent disclosure. Misappropriation of trade secrets occurs when someone acquires, uses, or discloses confidential information in an improper manner. To establish misappropriation, it must be shown that the information was a trade secret, that it was acquired improperly, and that it was used or disclosed to the detriment of the owner. While these are the basic legal principles behind protecting intellectual property, enforcing these rights can be challenging, especially in today's digital age where content can be copied and distributed instantaneously across the globe. Fortunately, advancements in science and technology provided us with powerful new tools for detecting and preventing IP theft. Digital forensics involves identifying the source of infringing materials, tracing the distribution networks, and recovering deleted or hidden data. This often requires advanced knowledge of computer systems and networks, as well as experience in data recovery and analysis. For example, digital forensic techniques may be used to trace the source of a copyright infringement lawsuit.
With the cell, I for some for I with for fry out of off by with that a fun if that I follow whereas that so for the why what to five for five
Investigators can identify the individual or entity that uploaded the content to the internet. Data analytics can help identify patterns of IP infringement, predict potential threats, and monitor online marketplaces for counterfeit goods. Large data sets of IP-related information can be analyzed to uncover trends and develop strategies for effective enforcement. For example, data analytics can be used to identify websites that are engaging in large-scale copyright infringement. By analyzing the website's web traffic data, investigators can determine the extent of the infringement and the potential financial impact on the copyright holders. And finally, we have artificial intelligence, which is increasingly being used to detect copyright infringement, identify counterfeit products, and monitor social media for instances of IP theft. AI algorithms can analyze vast amounts of data to identify subtle similarities between works and flag potential infringements. For example, AI-powered tools can scan social media platforms for images that are similar to copyrighted photographs. If a match is found, the tool will notify the copyright holder so that they can take appropriate action. As technology continues to evolve, we can expect new tools and techniques to be developed that will make it even easier to detect and prevent IP theft. However, it's important to note that while these tools are extremely valuable, they are not foolproof. It's crucial to use them in conjunction with traditional methods of IP protection, such as strong legal frameworks and robust enforcement mechanisms. In conclusion, protecting intellectual property in a copycat world is an ongoing challenge that requires a multifaceted approach. From strengthening legal frameworks to leveraging scientific advancements, every effort counts. By understanding the legal and scientific aspects of IP protection and staying informed about the latest developments in this field, individuals and businesses can better safeguard their innovations and creative works. As technology continues to evolve, so too will the methods of IP theft. However, with a proactive and informed approach, we can create a world that values and protects the hard work and ingenuity of its innovators. We hope you enjoyed learning about the science behind protecting intellectual property in our increasingly copycat world. If you did, please be sure to like and share this video with others who might be interested in this topic. Also, don't forget to subscribe to the channel so that you never miss out on any of our latest videos. Thanks for watching, and we'll see you in the next one.